Hello, my name is Professor Brett Davies. I'm a barrister and solicitor. Today we are going to learn about family trusts, otherwise known as discretionary family trusts. Now here is our law firm's website, and I'm going to go to trust. There it is there. There are many hundreds of different documents on our law firm's website, but I'm interested in family trusts, and we're going to build a brand new one today. So you can do deeds of variation, update the appointer clause, the trustees, change the name of the family trust, but I want to start a brand new family trust deed, and I'm going to learn all about family trusts. But firstly, why would I want to have one? Well, you end up paying less tax. They're quite tax effective, which we'll look at. What about a company versus family trust? Well, family trusts are completely unregulated. Therefore, from that perspective, they're better. What about a will? Well, to get a will, you've got to die to have the will valid. What about superannuation? Well, speak to your financial advisor and accountant, because super has some incredible tax advantages, and as it does family trusts. And why is it called discretionary? Why not family? Well, same name, but we'll check on that later. Now, in our yellow box, we can have a full look at the sample document, and this will be similar, not the same as the document we're building, depending on how you answer different questions. The trust deed is built on our website so that you will get exactly what the questions are based on our logic flow from our law firm. So here it is, family trust. You can put, if you're an accountant, financial planner or lawyer, if you're a lawyer like myself, you can actually put your logo on any of the documents you wish to. Just download it first. And there's the trust declaration to start it. There's the appointer, backup appointers. We're dealing with all these people. There's the children, cast of thousands. The categories. This is for the Bamfords case, and these new rulings, the ATO have issued new rulings on the effect of Bamfords, and it goes on for year after year. So the categories have been increased according to some of the ATO diatribe. Default beneficiaries, very interesting. Come to that. Trustees' powers, power to distribute. This complies with the ANZ, Commonwealth Bank, all the major banks. Be able to vary. Dealings with the trust deed, more powers required by the banks. Difference between the trustee and appointers we'll be looking at. The beneficiaries, most trusts have about 400,000 beneficiaries, and we'll explain why that's the case and why you shouldn't get frightened about it. Very important clause, the no partnership clause. Often the ATO will try and link the appointer to the trustee, and when they bankrupt the trustee, they try and take the appointer down with it, which is exactly what you do not want to happen. The appointer is the protected person. There's the minutes as required by your accountant, and there's a covering letter of a trust opinion certificate. So when the bank requires an explanation as to what is in the trust deed for loans, there's the letter. And that will protect the bank. That looks all good. I'd like to build one of these, but before we do, there's a checklist over here. So in the little yellow box, we can actually see the checklist as well. So as an accountant, financial planner, or lawyer, you can print that out. But I want to start building. So let's start the building process and press the blue button. Now, if you're not a member, the membership's free. All you do is go to sign up and put in your username. It's best to have the same username and same email for everyone in your accounting and financial planning practice. We've got clients that have done 400 or 500 different documents. That accounting house wants to, on a national level, wants to go back to that particular account, or on a state basis wants to go back to that particular account and get everything out. So I'm going to fill this out. I've logged in, or I've joined up, and the first thing I see is a big orange button to start my family discretionary trust. But if I've actually built wills, if the accountant or financial advisor has already built wills for their clients on our website, say it's the Thomas, then he could actually select Thomas, and all the data from Thomas's documents will go into the family trust. But I want to start this family trust afresh with just no old data in it. So the first thing is the name of the trust. Well, that is quite interesting, because you can name the trust anything you want. And there are thousands. Over the years, I've done over 18,000 family trust deeds online, and quite often many of them might be the Smith family trust, because Smith is a common surname in Australia. So you can name the trust anything you want. Johan Family Trust. Now the words "the" and "trust" are already in the document. Let's see what happens if I put them in again. They get taken out. Well, that's kind of useful. So that's the name of the trust. First question. But there are hints. So just let me show you that again. There are hints here which give, and training videos in those hints is to help you, guide you through building this family trust and understanding how this family trust works. Now, we are the only law firm in Australia providing legal documents on a website. All other websites are owned by non-law firms. So we want the protection, and most accountants and financial advisors, as cautious persons and lawyers that want to build documents online, will want the protection of a law firm. That's what you get when you're on our website. What are the questions going to be asked? Well, we know the questions being asked because we've downloaded the checklist. Why is the trust discretionary? Now, the family trust is known as either a family trust, a discretionary trust, or family discretionary trust. It's the same thing. The word discretionary is of interest because there is potentially 400,000 beneficiaries in a most modern family trusts, because it's not just you, your spouse, your children, your grandchildren, your great-grandchildren, your great-great-grandchildren, and all their spouses and children, and and your grandfather and great-grandfather. It's not just those immediate 400 or 500 family members. It's also any charities and anyone you have a shareholding with. So let's say you've got shares in Telstra, then all the shareholders of Telstra would most likely be beneficiaries of your trust as well. Now don't worry, because the beneficiaries have no rights. Even default beneficiaries have no rights under the trust. The only time that a beneficiary is required is when you want to make a distribution to that beneficiary, but the beneficiary cannot ask you for any money. So for that reason, you'd like to make every single person on the planet a beneficiary, but the Australian Taxation Office won't let you because it feels that the objects of the trust, the beneficiaries, are not certain enough. I remember many years ago being instructed by a Melbourne client to staple the Melbourne white pages to his family trust and then seek a private tax ruling from the ATO to see whether that objects are certain, and the ATO came back and said no, it wasn't, so it didn't work. So we draft your family trust as widely as we possibly can with beneficiaries. It could even include your ex-wife's new husband, which it probably does, but those people have no rights because they're beneficiaries. Your ex-wife may have some rights, but not because she's a beneficiary. There's a training video there. There's discussion as to what we've just spoken about. You can watch a training video on that topic. Now, let's talk about asset protection. There are 3 safe harbours. If you own a business, or you're an engineer or a doctor, financial planner, lawyer, a real estate agent, then you are high risk of bankruptcy. Oh no, Professor Davies, I've got insurance. Well, the insurance company may go bankrupt, or you may give, I as a lawyer may give accounting advice. Well, I've got no insurance for that, and I'll go bankrupt. And a financial advisor might give accounting advice. Well, that's in breach, so that the insurance won't cover it. There is high risk in being involved in a business or giving advice to people. And if you're in that situation, then you should look to the 3 safe harbours that you've got. The 3 safe harbours that anyone wanting to deal with asset protection should consider. The first is a clean skin family trust. And what I mean by that is a family trust with no assets in it other than safe assets like shares and property, but no at-risk business assets like employees. Don't put the employee in that safe harbour. Have 2 family trusts and have one which has the employees and has the risk, another that has all the nice safe assets like shares and property. The next safe harbour is your spouse. So in my case, my wife's a school teacher, so she's at low risk working for a government department. There's low risk for her, so I can put assets into my clean skin family trust, into my wife's name. Now, if my wife was to divorce me, I get half the assets back. Because we've been together for more than 8 to 10 years, we tend to split the assets back back to where they came from. So it doesn't matter whether all the assets are in my wife's name, all the assets in my name. The family court will merely distribute the assets as they see fit. So it doesn't matter if those assets all in my wife's name or not. Or indeed the family trust, the family court will also cut through the family trust and give some of those assets to your wife. The third safe harbour is your self-managed super fund and tax benefits, but also highly protected from asset protection. So clean skin family trust, your spouse, if your spouse is not working in a business environment, and your self-managed super fund, three great safe harbours. And if you ever want to talk about asset protection, go to your bathroom window, a bathroom mirror rather, have a look at it and say that you've just gone bankrupt and work out where your spouse and children will sleep that night. It's a very sobering conversation. So think about how you structure your affairs. And family trusts are a very common way of structuring your affairs in order to protect them from insolvency. That's asset protection. Well, some exotic family trust names that I've been involved in over the years. McScrooge Family Trust, Fortuna Trust, the Sweet Life, I think that is Dolce Vita. You speak Italian, Natalie? You don't, no one speaks Italian here? Yeah, I think it means a sweet life. My ex-wife family trust. These are not names I would be using. I think it just infuriates the tax office. I would stick to more cautious names of family trusts. And do I register my family trust name anywhere? No, it's not. And it's not something that's registered. It's just the name of your trust. It's like a nickname. Now, how many trustees are you going to have? Well, that's going to come up next question. You can have one or you can have more. So I've got the name. I've got one little tick there, which means I've given the logic flow the correct information. So I'm going to press next. So these questions down to the left-hand side all need to be ticked before we're going to be able to finish our document. Now, the trustee of a family trust. What's the difference between an appointor and a family trust? Well, you can watch the, gee, my mouth looks a bit open there, doesn't it? There's a training video, but let me talk about the difference because it's a critical and vital question as to the difference between the appointor and the trustee. And it's summarized in the one sentence. And if you know this, one thing I'm about to tell you, you'll know more about appointors than most lawyers in Australia. And it's this. The appointor is God. The puppet is the trustee. So trustee is a puppet. The appointor is God. If you remember that, then you're well ahead of most people in Australia. Why? Why is the appointor God? Well, the appointer hires and fires the trustee at whim. So for no reason, if you just don't like the trustee, for whatever reason, you can sack the trustee. That's what the appointer does. It sacks the trustee. Now, there's other names for appointers. And other names might be controller, principal, guardian. The most common expression is appointer. In fact, in the family trust you're building at the moment, we use the classic terminology, and that's the appointer, which hires and fires the trustee, and the guardian, which tells the trustee who gets the income and capital every year. But for the sake of this training video, the appointer is the person in control. The appointer will hire and fire the trustee, and the appointer guardian will tell the trustee at the end of the year, or just before the end of the year, where the income and capital is to go to the beneficiaries, if there was any income or capital distributions. So what's the trustee? Well, the trustee is the legal owner. It looks like it's the boss, but it's not. It's the legal owner of the assets, but it does not own the asset beneficially. The assets are beneficially owned by all those thousands of beneficiaries underneath your family trust. So God will tell the trustee who gets the income and capital. God will hire and fire the trustees it sees fit. The trustees will own the assets, but only in trust. And what a wonderful system that is. And it's the very essence of the beautifulness, of the wonder of a family trust, because the trustee has all the risk of being the legal owner. The appointer, who's the controller, has no risk at all. but has all the power and rights, and that is the beauty of the family trust. So let's now have the family trust go insolvent. There's a song that Michael Jackson, a great USA singer, now deceased unfortunately, he sung this song, "One bad apple spoils the whole darn bunch." One bad apple spoils the whole darn bunch. Now, that is a very important message to give. If you have a family trust, and you might have, say, 12 assets in it, 11 properties and one business asset, which you're not meant to do, but let's say you do, that 12th asset, the business asset, if it causes insolvency, if it has a $100 million claim or $1 million claim against it, it will contaminate and use up all the other assets in the property. So let's say you get a $30 million claim because of something you did in your business, and the business asset was in the family trust, then all assets in the family trust must now be used to extinguish and get rid of that debt. So you lose all 12 assets, and that's why you need a clean skin family trust. Well, okay, fair enough. So you're going to have a family trust with only the evil, dangerous business assets in them. But let's now assume that that family trust has gone insolvent, gone bankrupt. What happens to the trustee? Well, it's likely, particularly if the trustee's been a guarantor, it's likely that the trustee will go down with a sinking ship. So for that reason, you might want to have, in that case, a company as the trustee. And how many directors do you need? How many directors do you need for a company? 2? No. You used to have 2 directors for a company, but under the Corporations Act, it was amended many years ago, you now only need one company to be, one human being to be a director. So if the company goes down, the director may go down with the company, but only one director will go down. So asset protection is a critical issue. Appointer is God. Trustee is the squashed cabbage leaf, the mere puppet. Now, I want to know whether it's better to have a human or humans as a trustee, or have a company as trustee. So let's talk about that. And obviously you can watch the training video on that and learn a lot about that. A company costs money. You can build a company on our website, but that costs a lot of money. The government charges a lot of money for that, and then every year you have to pay ASIC fees to keep the company going. You don't need to do tax returns if the company's not trading, but you will need to have an ASIC yearly fee. So that costs money, but the advantage of a company is that it is another firewall between you and bankruptcy. So from that perspective, it's not a bad idea to have a company. It also has perpetual succession. So if the trustee was a human being and died, let's say you were the appointer with your wife and you made yourself the human being trustee, and you've got 5 properties in the family trust, you'd have to now, thanks to your death, transfer your wife as the appointer will have to put in a new trustee and transfer all those properties from your deceased name into the company name. There's a bit of work in doing that. Whereas if you had a company and you died, you're the director, then you just replace the director, or let's say you're the shareholder, well then the new shareholder, your wife, would just take over the shares of the company. Not very expensive at all. So a company is superior from that perspective of both asset protection and succession planning, but it does cost money. It's cheaper just to have yourself as the trustee. Your call. Now, we in Australia have a set of tax laws, or looked after by the Australian Taxation Office. We also have different states requiring different land tax rates and stamp duty if you're a foreign company. So my advice to you is that your trustee, whether it be a company, an Australian company with an Australian director and Australian shareholders, or whether it be a human being, they should be Australian residents as best as you can to get rid of the complexity with international tax issues. Now, I'm going to opt to have a human being, and the details go in there. I can add another trustee, but here my accountant's saying, Brett, I want a company as trustee. Okay, Mr. Accountant, I'll have a company as trustee. And I did form a company yesterday. 2J nominees, Pty Ltd. It's ACN, must have 9 numbers, and it only allows for 9 numbers. What is an ACN? We'll read the hints there if you want to. The company needs to have an address. This does not need to be the registered office of the company. It can be any address. It could even be your home address if that suits you. I can add another trustee, but I'm pretty sure that one corporate trustee will be good enough. Now, as I press next, my information is now saved. I can come back in years later, tomorrow or years later, and just pick up from where I left off. Just log back in again and go back to that particular document. It'll take me to all the data will be preserved. Now, I've done the trustee, which is the squashed cabbage leaf, just merely a puppet of the appointer. I'm now going to do God. And this is very interesting because this is a critically important person, and therefore I'll make it myself. Very rarely would you make it a company, but you can. So I'll make it myself. Davies. Now, because in the good old days, used to put the man in, but obviously now we're all liberated. Same-sex marriages, all that sort of thing. We're all liberated society, so I would need to put my wife in as well. Muriel May Davies. So together we are the appointors. We have to act unanimously. But there again, if I fight with my wife, she'll probably get me into the family court anyway, so I'm not too worried about that. Now, the backup appointors, that's a great service we're providing here. When my wife and I die, we're leaving everything to our children. We've got 4 children, say. What I'm going to do is put all 4 children into this as a backup appointor. So when my wife dies, I remain the sole appointor. But if my wife dies first, I remain the sole appointor. And that's good. We're in control. But after we both die, our 4 children will be the appointors and have equal control and say of the assets of the family trust. Good succession planning. But Professor Davies, don't the assets go into the will when I die? No, they don't. Your family trust in all jurisdiction other than South Australia will go for the length of 80 years. Now, during that 80-year period, there is stamp duty and capital gains tax implications if you make a distribution out of your family trust. So when you and your wife die, the assets will not, and normally don't and should not, go from your family trust into your will. So therefore, you need to have proper succession planning. And if you're in a happy relationship, your wife and your husband are the appointors, co-appointors, then after you both die, it will be the 4 children. So here I'm going to put the union of my full name and my wife's full name. If I make a mistake, I'll get the documents will be checked on the summary page, and I'll just go back to make any changes I need. That's the way to do it. The children of the union of mum and dad. Now, what's these hints all about? Backup appointors. So that explains the difference between the appointors and the trustees. Are you happily married? Then you appoint it. And I am in this situation, so I am in real life as well. And therefore, I've made my husband and wife together the appointors. Should I name a backup appointors in my will? Oh my goodness. Oh my goodness. Please don't do that. And please have a look at, if you've got old family trusts, have a look. Make sure you do not have legal personal representative as the backup and your appointor. It's the worst thing you can ever do. The will is a grubby little document that can be challenged by your parents, your wife, your spouse, your mistress, a gay partner. And you can have all of those people. You can have all 4 of those people if you can afford it. Bigamy is alive and well in Australia. Your children can challenge the will. Your grandchildren can challenge the will. What a disaster. In a family trust, apart from your wife, your spouse, no one can challenge a family trust. They are beautiful. They're elegant. So don't let God, the God position, the appointer position, be contaminated by putting it into a will. You did that, did you? and you think it's the right thing to do? Well, let me tell you a story. The farmer has decided he's going to leave the farm worth $20 million to his son and just leave a couple of apartments in South Yarra to the two girls, so $1 million apartments to each of them, because he wants the son to keep on with the farm. But his accountant tells him that when the assets go into the will, the two girls can challenge the will. So he spends hundreds of thousands of dollars of stamp duty and capital gains tax moving the farm into the family trust, because now it can't be challenged. He makes the appointer, himself and his wife, and upon the death of both of them, the appointer will be not his son, but the legal personal representative, which is the executor named in the will. All good so far, because he names his son the executor in the will. This is very common. It's stupid and wrong because of this reason. Mum and Dad die. There's Dad's will. The appointer is the executor, the son's the executor. He's very happy with that. The two girls go to their lawyer and say, we've been gypped. There's a $22 million estate and we're only getting $2 million of it. And the boy, our brother, is getting a $20 million farm and we're only getting a miserable $1 million apartment each. And the lawyer looks and says, well, I'm sorry, but there's no point challenging you the will, because the only thing in the will are these two apartment blocks. The farm's in a family trust and we can't challenge the farm. But hang on a minute. Getting excited there, losing my sound controller. But hang on a minute. I see here there was a fault in the drafting of the family trust deed. I see the legal personal representative controls where the super goes. What we'll do, we'll go to the Supreme Court, who has the power to rewrite your dad's will, and we'll have you, both you girls and your brother, as three appointers in the trust. So that means the three of you now control the trust. Really good. So they go to court and they get a court order to say the executor's amended to make it all three. There's a breach, or the family trust has been poorly drafted, not like the one you're drafting here. The ones we do don't have this problem, but a lot of modern and old family trusts allow a majority of appointers to control the minority. Let me say that again. So the God position is the appointer, and the God position can be controlled by a majority of people. In this instance, the two girls under this poorly drafted family trust deed can control 100% of the family trust. So the two girls together decide to sell the farm. They kick the boy off, or get the police over there and get the boy in his ute off the farm. They then sell it, pick up the 20 million, 10 million each, and they go about their business. All because you let the will contaminate the family trust. So speak to your accountant, the accountant will have the appointers being the backup appointers named here in this clause. I want my wife as a backup appointers and then the children. A little bit old-fashioned. I'd make it both yourself and your wife. If your wife divorces you, you're going to lose half the assets anyway. It doesn't matter who the appointer is. The family courts don't care about appointers. They just split the assets. And if you've been together for 8 to 10 years, you tend towards a 50-50 split. Get over it. There's nothing you can do about that. There's no way you can structure your affairs in order to stop your wife from doing that, or spouse from doing that. Just make it both of you together as appointers. Now, in my case, when I first did my family trust deed, I was not married and didn't have any children, so the backup appointer was merely I think it was my mother at that stage, which I've now amended and made it my wife, and then my son after I die. I could have made it my wife and myself. In fact, I think it might be my wife's the appointer of my trust. I can change it as often as I see fit, and I feel that's just another document you can build on the website. But let's say I split up with my wife and I have more children, and I get control of the family trust, then I'll just want to have it the children of my full name, not of my wife, because my wife might have more children to another man. So you can do whatever you want to do here. But whoever these people are, after you and your wife die, or after the current appointers die, these are the next people in control. And you can always change it. You change it tomorrow or in 20 years' time. But I'm happy with that. So let's now look at the set law. Now, the only time a family trust has been attacked was by King Henry VIII in the Statute of Uses, which is what year, Natalie? 1535, 34, 1534, 1535. Well, anyway, around 1535, King Henry VIII decided that family trusts were a little bit of a tax haven, and they still are, and therefore imposed a restriction to the Statute of Uses so you couldn't do family trusts anymore. Some smart accountant or financial advisor, perhaps someone like yourself, came up with the idea of inserting a set law that settles a farthing, now 10 Australian dollars, into the fund to start the fund or to start the fund off. So the concept of set law came about because of the Statute of Uses in 1535, and we still today doing Australian family discretionary trusts, much like you can build on our website. You have a set law and they settle the first $10 onto the trust. Now, the only problem with that is that the only person you can't distribute ever to is the set law. So make sure the set law is someone you don't like, your lawyer, your financial planner, or your accountant. Just joking, you should love your financial advisor, accountant, and lawyer. But you need to have someone that's not part of the family. Have someone that's a stranger, next door neighbour, or someone that your children won't marry, because you can never make a distribution to them, to the set law, and you can't make a distribution to set law's children when they're under 18. So the set law should be someone you don't really know. So I'm going to appoint a set law. I'll make it Mark Chen. He's in, look at that. See, that says Hobart Road RD, but we don't like that. We don't like abbreviations, so it goes into his road. This is a beautiful system. So that's the set law. Now, the set law, lots of hints there, who the set law should be. Should the set law be a stranger? It should be. So I've got that. Let's see if I get a green tick. Yay, I've got a green tick. Look, there it is. So now the settled amount, look, I just put $10 in. I've never had a problem with it. If you're worried about it, get a $10 postage stamp and staple it onto the deed, or get a $10 note and staple it on. But I don't think you need to worry. Or if you don't think $10 is enough, then make it $100. It doesn't make much difference. The AT, I've never issued a ruling to say that it has to be anything above $10. So I'll opt with $10. No, I'll make it $100. There we go. No, I won't. I'll make it $10. That's just how I like it. So that's a set law amount. Now the default beneficiaries. Whoa! It's inserted data from a previous question. It says the children of the union of Brett and Muriel. Wow. So what's the difference between default beneficiaries and backup appointors? Well, a beneficiary is different to an appointor. The appointor is God and directs the trustee what to do. The beneficiaries are those thousands of people underneath that get the wealth, of which probably the appointor is one of them. Pretty much always is. So the default beneficiaries are very rarely ever used. The default beneficiaries are only used if you, the appointor, forget to tell the trustee to do a distribution before the end of the financial year. So I might well decide that I'm going to pay certain amounts of money to different people, and you get trust distribution minutes with this trust deed. But I forgot. It's virtually impossible to forget. No one forgets. But let's say you forgot, then whoever are your default beneficiaries will get the income you earned. If you don't do that under Section 99A, the tax is the highest marginal tax rate, so you don't want that. But it's very unlikely you ever use default beneficiaries, but you've still got to put them in the trust deed. Now, the other purpose, so the first purpose is if you forget to make a distribution of income within this financial year, your default beneficiaries get the income. Okay, that's fine. But this trust goes on for 80 years, except in South Australia. But even in South Australia, any beneficiary can collapse the trust after 80 years. So it's pretty much 80 years in Adelaide as well. After 80 years, the trust has to vest. which means it has to be paid out. You can only keep a trust going. It's the law of perpetuity, and also based on English law. So after 80 years, the trust must vest. Now, just before the end of 80 years, now I know your current appointers are dead and your children are dead and it's a great-great-grandchildren be running the trust at that stage, but whoever they are, the appointors need to tell the trustees who to distribute the income and capital to for the last time. Let's say the appointer forgets to tell the trustee who the default, or who will get the wealth when there's a vesting. So default beneficiaries are not that important unless you forget to do something. The other names, there are other expressions, so takers in default, named beneficiaries, primary beneficiaries, main beneficiaries, capital beneficiaries, they're all the same thing. If you're single with no children, then and that was my position, my default beneficiary was just myself. The question about how do you ascertain these 400,000 beneficiaries, Brett, that are in the trust? Well, they come from the trustee, the appointer, and the default beneficiaries, and the backup appointer. So it's all the children of Brett and Muriel. It's all the children's children of the trustee, and quite often the trustees are companies, so it'll be all the children of the director. You want to make the class as wide as possible for the general beneficiaries. So they're not named. You don't put you don't type in the name of 400,000 people, the general beneficiaries. They spin out of the rules and regulations of the trustee. The difference between backup appointors and default beneficiaries, we've been through that. The backup appointors are gods that control the trust after the appointors die. The default beneficiaries just are beneficiaries that get everything. Well, what's the difference between a general beneficiary and a default beneficiary? Well, the general beneficiary is exactly the same as a default beneficiary, except the default beneficiary gets assets if you forget, gets the income if you forget to distribute. The default beneficiary doesn't have any more powers or rights. No beneficiary has any power. That's one of the beautiful things of a family trust. Beneficiaries are just of no value. They're, I should say no value, but don't have any say in the matter. Now, if you why is the trust called a family trust, and why is it sometimes called a discretionary trust? Well, the question of a family trust is to do with the appointors, because you can see here that it's really the appointors that control the trust, and they've got to do it unanimously. So it's really just the family, and it starts to break down when your children's children, all 42 people are appointors, and they're all wanting to do different things. It's a real mess. So family trusts are often best when it's just you and your spouse. The default beneficiaries are the ones that you name, which will get the income, where the general beneficiaries are just general beneficiaries. They don't have any more rights or any greater rights than default beneficiaries, unless you forget to make a distribution. Now, I want to talk about some of the dangers of making distributions to children, talk about the distributions that happen in family trusts. So just before the end of the year, you'll do a distribution to everyone to bring them up to the marginal tax rate, which is 0. Then you bring them all back up to the next rate, and then up to the next rate. So if your spouse is on no income, you'll immediately distribute up to the lowest marginal tax rate, and then up to your tax rate, and then your children's tax rate. If your children are over 18, then you get an adult tax rate threshold. And just keep doing that in the family trust minutes, distribution minutes, and you'll see that when you've got the trust distribution minutes. So what you're doing is you're hunting down people on low rates of tax, because the highest marginal tax rate is getting on to 50%, 50 cents in the dollar. But might be some children that are actually earning no income because they're swanning around at university using your coin. So you make a distribution to them. So let's say you make a distribution of $35,000 to young Johnny. Well, young Johnny never sees that money. You pay the tax, you do a tax return for young Johnny, and you pay whatever tax is owing on that $35,000 out of the family trust assets. So Johnny's not out of pocket. But let's say that you made a distribution to Johnny of $35,000. The tax on it was $5,000. Now you owe Johnny $30,000. Well, Johnny's never going to get that money. He doesn't get the money. It's just a notional amount of money that he was given in order that he had to pay tax on. So if Johnny was to now die, you, the family trust, now have to pay Johnny's estate that $30,000. You don't want that. If Johnny mixes about with some second-year law student at university who's suffering from cocaine addiction and gets your son involved in cocaine, then Johnny will want to come to you and say, look, I'm addicted to drugs. I need $30,000 to buy some drugs, and you have to pay the $30,000. Or Johnny may go bankrupt, in which case the trustee in bankruptcy will ask, is there any unpaid present entitlements, which these are called. They're like similar to loan accounts, unpaid present entitlements, UPEs, unpaid present entitlements. And they'll ask, so look, any UPEs, any unpaid present entitlements are owing to Johnny. It's $30,000. You have to write a cheque for $30,000, the trustee in bankruptcy. Well, that's not very good, and particularly if you do it every year for 10 years, it's now $300,000 you owe young Johnny. He gets married, gets divorced. Well, you've got to pay half of it to his ex-wife. So what you need to do in order to wash out or get rid of the unpaid present entitlements, you can do another type of document called a deed of debt forgiveness, and you can build them on our website. In fact, you see the covering letter. It's a work of art, and you can actually, for love and affection, forgive the unpaid present entitlement each year, which is what I do. And so that the unpaid present entitlement gets down to zero. And therefore, if Johnny goes bankrupt or whatever, no one can come back to you. Well, less chance than coming back to you. But what about if you've got children under 18? Because a child under 18 years of age can generally not enter into a legally enforceable contract. So what you do then is let's say you make a distribution of whatever distribution you make, every time you give the child a Christmas present, a birthday present, they sleep in your house, the 6-month-old gets a baby chair or whatever, that all comes off the money that you owe the child through unpaid present entitlement. So every year the accountant will be instructed to wipe off the UPEs, the unpaid present entitlements for that particular underage child, back to zero. So when the child turns 18, there should be no unpaid present entitlements owing. It's a trick for young players. Don't be very fearful of making gifts to the children. So I've now got green ticks all the way along. That's fantastic. So what's next? Now, the next page is the reference page. Now, if your accounting house has done, let's say you've done 200 or 300 family trust deeds on our website, and you want to be able to find them again, so you might put in your reference. So PKD with the client ID, or you might put Peter J. Smith, if that's the client name, and that you can now trace that. You can actually search that many years later back to when you go back to your documents. You can actually go back and search them all. That's good. The next thing is, if you've put on your profile, if you've downloaded the accountant, financial planning or law firm logo, if you've downloaded it and you press yes there, the logo will appear on the front page of the will, which is quite snazzy, and most accountants, financial advisors and lawyers opt for that. And I'm going to do that. So here, identify your client is above, and would you like the logo on your document? I'm going to press yes. There it is. And my logo will now appear. Now, with all our documents, you're now given the opportunity to look at the sample to make sure the spelling's correct. 2J is misspelled, so I'm going to go back and just fix that up. 2J needs to be corrected, so it's saved all the data there. 2J, I'm just going to go with a Y. There we go. Toye. It's now Toye. That's great. I'm going to go back to summary page, see what else is going on. I could go straight to lock and build, but I don't want to. I just want to check all the spelling. New South Wales, correct. Names are correct. My reference is in, and the logo is on. I'm happy with that. I'm now going to press lock and build and put my credit card details. So I've paid for my document, and now I'm going to access my document. So it's been saved on a hard drive. It's been emailed to the email name you had. I can also come back right now or tomorrow or in 20 years' time and grab that particular document, print it back out again, or email it to my client. There it is there. There's my invoice. Let's have a look here at the document I've built. So you can print it out, sign it, do whatever needs to be done. There it is down here. So there's my corporate logo. And there it is. There's the 2J nominees, that address. And the settlor, stranger. Appointor, there it is there. It's my wife and myself. Here's the backup appointors, the children of myself and my wife. Still definition sections. Now the categories are critically important. The changing of the Bamford, this is to allow franking credits, attribution, separate accounts, and it's the Thomas and the Federal Commissioner of Tax, 2017. Critical changes were made to Bamford's, how Bamford was looked at that point. So you really need to update trust deeds which are prior to 2017. Also the loss recruitment. You need to be able to retain and stream losses for particular beneficiaries. The appointor acting unanimously is in here. So we don't have that problem that farmer had. There's the bank loans to family trusts, so it's compliant with CBA, St George, NAB, ANZ Bank, West, AMP, Queensland, Macquarie, Citibank, ING, Bendigo Bank, One and Westpac, amongst other banks as well. So all the latest changes are in there. And there's my reference. See that reference? That's the accountant's reference that you put in. I asked for it to be on every page. Now, if you've made there's a spelling error or you want to change something, just email us and we'll send you a voucher to redo the document again using the same data. So they have 100% money back guarantee in every single document that you build on our law firm's website, and you are on a law firm's website. You haven't come off to someone else's website. This is a critical issue of reducing tax and stamp duty. The trust deed is very tax effective, and I'm an adjunct professor lecturing at 3 universities in tax. I have 7 degrees, 4 of them of which are law degrees, and my doctoral thesis was on this taxation issues. We also allow for trust cloning, splitting and umbrella trust structures as well. There's the minutes and there's the covering letter. So congratulations, you've built yourself a family discretionary trust. It's fully compliant with all the new rules and regulations. During the time when you did that, you could have done a chat with us, you could have telephoned us. We're always available if you need anything. Enjoy this wonderful website and hope you've enjoyed the training video. Give me a like on, as my little boy says on his YouTube channel, give me a like on YouTube. Enjoy.